Hello friends, we have seen that citizens have following remedies for environment protection in India in case of any environment wrong. A common law remedy in torts, criminal law remedy under IPC, CRPC, citizens suit provision under Water, Air, Environment Protection Act, Public Liability Insurance Act 1991, National Environment Appellate Authority Act 1997, PIL and National Green Tribunal. We have seen in detail about a common law remedy in torts, citizens suit provision under Water, Air and Environment Act, Public Liability Insurance Act. Today we'll see about PIL. PIL is a very famous word in India. Public interest litigation or social action litigation is permitted by the Supreme Court and High Courts under writ jurisdiction at the instance of public-spirited citizen for the enforcement of constitutional and other legal rights of any person or groups of persons who because of their disadvantageous position are unable to approach the court for relief. The Supreme Court under Article 32 and the High Courts under Article 226 can be moved by any public-spirited citizen or NGO for the prevention of environmental pollution in India. PIL. In India, public interest litigation means litigation for the protection of the interest of the public. It is the litigation introduced in the court of law by the court itself or by any other private party. Thus, public interest litigation is not filed by the aggrieved party. As far as jurisdiction of the court is concerned, it is not necessary that the person who is the victim of the violation of his or her right should approach the court personally. PIL is the power given in the hands of the public by the courts through judicial activism. Such litigations may happen when the injured party does not have the necessary resources to commence litigation, or when his freedom to move to the court has been suppressed or encroached upon. Moreover, the court can itself take cognizance of the matter and proceed suo motu. Moreover, any public-spirited individual can also file a public interest litigation on behalf of the aggrieved party. In India, any public-spirited person can file PIL on behalf of a group of persons whose rights are affected. It's not necessary that person filing a case should have direct interest in the litigation. For example, a person in Bangalore can file a public interest litigation for the malnutrition deaths in the Orissa. Any person can file a PIL on behalf of a group of a person to compel municipal authorities to perform public duty. Any person can file a PIL in Supreme Court for taking action against cracker factory that is employing child labor. However, it will depend on the facts and circumstances of each case whether such litigation should be allowed or not. However, the strict rule of locus standi applicable to the private litigation has been relaxed by the Supreme Court. PIL can be filed only against state government, central government, municipal authorities and not any private party. However, private party can be included in the PIL as a respondent after making the concerned state authority a party. For example, in case of private factory in Delhi causing pollution, then people living in its vicinity or any other person can file a PIL against Government of India, the State Pollution Board, and also against the private factory. However, a PIL cannot be filed against a private party alone. The concerned state government and state authority has to be made party. When PIL can be filed? A PIL can be filed when the following conditions are fulfilled. There must be a public wrong and public injury caused by the wrongful act or omission of the state or public authority. For the enforcement of the basic human rights of the weaker section of the community who are exploited, ignorant, or whose fundamental and constitutional rights have been infringed, it must not be frivolous litigation by person having vested interest. Examples: PIL. A PIL can be filed by a person only in case where public interest at large is affected. merely because only one person is affected by state inaction is not a ground for PIL. Some of the possible areas where PIL can be filed can be illustrated with the help of following example. Where an industrial unit or a factory is causing air pollution and people near to that area are getting affected, like Ankleshwar, where in an area or in a street there are no street lights causing inconvenience to commuters, where some banquet hall is in a residential area plays a loud music at night and causes noise pollution, where environment pollution is being caused by some construction company by cutting of trees, where poor people are affected because of state government's arbitrary decision to impose heavy tax, for directing the police or jail authorities to take appropriate decision in regard to jail reforms such as segregation of convicts, delay in trial, production of under trial before the court on remand dates, for abolishing child labor and bond labor, like that. Procedure to file PIL. Procedure in High Court. A PIL is filed in High Court in a form of writ under Article 226 of the Constitution of India, and then two copies of the petition have to be filed. Also, an advance copy of petition has to be showed on each respondent, opposite party, and this proof of service has to be affixed on the petition. Procedure in Supreme Court. If a PIL is filed in Supreme Court, like under Article 32 of the Constitution, then 4 plus 1, 5 set of petition have to be filed. The opposition party is served the copy of the petition only when notice is issued. Procedure to file PIL in High Court. Proceedings in PIL commence and carry on this same manner just like in the other cases. However, it is important to note that in between proceedings, if the judge feels he may appoint a commissioner to inspect all allegations like whether pollution is being caused, trees are being cut, or there actually exist severe problems, etc. After opposition party files his replies and the petitioner files his rejoinder, and the final hearing takes place, the judge gives his final decision. In People's Democratic Union versus Union of India, letter addressed by the petitioner organization seeking a direction against the respondents for ensuring observance of the provisions of famous labor laws in relation to workmen employed in the construction work or project connected with Asian Games was entertained as a PIL. The Supreme Court has encouraged the filing of PIL for tackling issues related to environment human rights. The last point of the PIL we'll discuss. Can a letter explaining certain facts to the Chief Justice to be treated as PIL? Hello friends, please think. Can a letter explaining a certain facts to the Chief Justice of India to be treated as PIL? Yes, in India there have been instances where judges of the court have treated a postcard containing fact as a PIL. For example, a letter alleging the illegal limestone quarrying which devastated the fragile environment in the Himalaya foothills around Mussoorie was treated as PIL by the court. Thank you so much friends for listening me patiently. Thank you so much.